Thank you, everyone, for attending today's program. That was my dog, Cosmo. He's very cute and very loud. For those of you who are joining us for the first time, I'd like to introduce you to SHALVA. SHALVA's mission is to support survivors of domestic abuse in the Jewish community through counseling, supportive services, and community education. We have a lot more information about SHALVA included in our materials packet, and you'll see the link right there in the chat. Throughout our program, we may use both she and he as pronouns when discussing survivors and perpetrators of domestic abuse. While the survivors in the vast majority of reported cases of domestic abuse identify as female, we acknowledge that males and non-binary individuals also experience domestic abuse. But sadly, their cases are not as widely reported, so that skews the numbers. I also want to mention that if you're triggered by anything in today's program, the program is being recorded. You can come back to it later. And also you can reach out to your mental health professional or call SHALVA at 773-583-4673. So now I have the honor of introducing our speaker for today. Helen Bloch is someone that I've known for a few years now through her work with the Decalogue Society. She founded the law offices of Helen Bloch PC, a general practice firm, over 20 years ago. She helps individuals and businesses navigating employment matters, negotiating business agreements, and starting their own businesses. In addition to counseling clients and drafting their policies and procedures, she also provides training on sexual harassment and discrimination. Outside of her practice, Helen is a guest lecturer and a member of several civic and professional organizations, including the Women's Bar Association of Illinois. And as mentioned, she was a past president of the Decalogue Society. The society also awarded her the Presidential Citation in 2015, congratulations, and its Inter-Society Award of Merit in 2001. Since 2019, Helen has been included in the Illinois Super Lawyers list for employment law. So both the chat and the question and answer are open today. We will be using both functions, but if you have a question specifically for Helen, I'd ask that you put it in the Q&A. It's just easier to keep track of questions there than as the chat rolls up. Sometimes things get lost. So with that, I am going to turn it over to Helen, and I am going to hide myself.
Well, thank you very much, Vicki. I'm really happy to be here on behalf of SHALVA. It's one of the organizations that's near and dear to my heart. It does fantastic work. Every time I go to my synagogue and I go into the bathroom, I see the SHALVA notices on the back of the bathroom and also at the mikvahs in the Chicago area. So I'm so glad that there is such an organization that does such fantastic work for our community. And I encourage everyone to support SHALVA if they don't already. And with that, let's get into our presentation for today. So let's say you know Sarah. Sarah is going through a miserable divorce. Her husband is very well-to-do, well-established in the community, has lots of money, they have kids, and it's just dragging on and dragging on and dragging on. But she decides to pick herself up, and it's time to go back to work and to look for a job, and she decides to ease her way back into it by getting a job as a salesperson at Neiman Marcus in Northbrook Court. So she goes to Neiman Marcus, she puts up displays, and after working for Neiman Marcus for a few months, her ex, or soon-to-be ex, is aware that she is working at Neiman Marcus. He has patronized the store before, he has spent a lot of money at Neiman Marcus, and he decides to go and shop at Neiman Marcus. And while he's going and shopping at Neiman Marcus, he happens to see his spouse, and he starts trying to talk to her. Gee, you look beautiful today, hon. Why don't you come back home? You know, the kids, you know, could really need us all back together. And she says, look, I don't want to talk to you. I'm at work. Please leave me alone. And then he keeps coming back at her and saying, look, you know, we don't have to go through this. It's all because of you. And he starts making abusive comments to her. And she says, look, I'm at work. You know, please leave me alone. And then he starts stalking her. He follows her around the store. He wears sunglasses. He wears a hat. He goes behind certain areas at work, into the aisles, watching her. And it makes her feel incredibly uncomfortable. So she decides to report it to her supervisor. And she says, look, you know, this is my ex-husband. And I'm being stalked in the workplace. He's coming in sometimes once a week, twice a week. I don't want to talk to him. He's making comments to me that I don't appreciate about the way I look, about our children, and it makes me uncomfortable. And then he's stalking me. Sometimes I see him in the parking lot. Well, what do you think the employer should do in this situation? If you guys have thoughts, please feel free to put it in the chat. And
I think that there might be a chat issue. Someone has said that their chat isn't working. So if you want to raise if someone wants to raise their hand, they can, and I can allow them to talk. So please feel free to raise your hand. You can try putting in the chat. I don't know why it's not working.
It's okay. I like to hear people's voices anyway. So I wish I could see them too. So feel free to participate and let me know your thoughts. Do you think the employer should do something? Do you think the employer should just say, hey, this is a domestic relation situation. Why don't you call your divorce attorney and have them handle it? So what are some of your thoughts as to what Sarah should do, what the employer should do? Happy to hear. I'll wait like a few moments, and if not, I'll continue.
I got someone that just raised their hand. Let me see who it is. Oh, things never work the way I want them to. Okay, looks like Linda. I'm going to allow you to talk, Linda. And I'm even going, yeah, there you go. Linda, you can go ahead and talk.
Can you hear me?
Yep.
Yes.
Okay. Okay, first thing that I would do as a person is see if I can make me a police report. So when I go to them, I will have something to show them. Because I don't know, they might tell me that's the best thing I should do first, because they want to say, well, he's a customer, he's coming in here, you know, shopping, something like that might take place. And if they don't do anything, then we're going through another step. So I think the best thing is just to get a police report first, and hopefully that I can take that to my employer, and that would give them something to go on.
Okay, so you think Sarah should go and get the police report?
I would I would.
Okay.
But sometimes everyone doesn't feel comfortable doing that either. So she is turning to her employer for assistance.
Okay.
So I understand that also.
So Linda thinks that as a first step, she should contact the police and see if she should get some kind of order of protection. That's the way legally I would put it, and see what happens. I see Rita. Rita has her hand up. Rita, what are your thoughts?
My thoughts are that I would go to the divorce attorney that was handling her case and see if she could get a restraining order, given that my experiences in family courts, they do not like to give out orders of protection, but they will give a restraining order. The only problem with that is that usually they're mutual. And women have a hard time understanding if they're going to the divorce attorney and saying, look, this is interfering with my personal liberty. This is, you know, not patterned yet, but it's actually the beginning of stalking. I could lose my job. This is intimidation. Why am I now offered a restraining order against him, which I have to also be named in? So a lot of times women don't like that, but if they have an advocate can explain to them, right now, currently, this is the best that we're going to be able to do. And the court realizes that he is the offender, but let's see, you know, if we can get over this hurdle. That's what I would do.
Okay. So Rita also thinks Sarah should do something affirmatively herself personally and contact her divorce attorney and spend goo-gobs of money that she's already probably spent and go through the legal process on her own with respect to her divorce. I see David Kaufman. Hello, David.
Hey, Helen, how are you?
What are your thoughts? Yes, I can.
Beautiful.
Let's hear your thoughts. I don't think David practices domestic relations, so I'm guessing David has a little bit of a different angle. What's your angle, David?
So the employer has a level of duty to keep a safe working environment for its employees. And therefore, I'd want to see Sarah go immediately to HR and explain to HR what's going on and see if some protection can be put in place, or have the current but soon to be ex-spouse removed from the premises.
Okay, so David is starting to hit the nail further into the ground that I'm about to get into in terms of the responsibilities of the employer once they're on notice. And that's a very critical term, because according to the case law that I have distributed to you, both the Costco case, which I'm going to get into in a little bit, and also Wong versus Midwest Gaming, the employer has to be on notice. The employer cannot be held responsible to keep the employees safe in the workplace unless they are on notice. Once the employer is on notice, they need to take reasonable corrective measures to ensure a safe working environment. So the cases that I provided to you are not in the domestic relations context. I've switched up the facts a little bit, but the premise is still the same, because under our various employment laws, which I'm going to get into, especially under the state of Illinois law and the city of Chicago law, employers are responsible for keeping their employees safe from customers, from third parties, from vendors. So it doesn't make a difference how much money these customers spend at the store. The employer still has ultimately the responsibility to keep their employees safe if they're on notice. So for instance, in the Costco case that I provided to you is a very interesting case. There was a woman who was who worked at Costco, and there was a patron of Costco who repeatedly, where she was working, would ask her, "What's your nationality? Why were you talking to those other coworkers? What were you saying to that male coworker I saw you talking to? You're beautiful. You're pretty. Come on, come out with me." He would like put his business card in her hand. And she reported repeatedly to the employer that he was scary, that the comments made her uncomfortable. Initially, Costco's response was, "Well, gee, he's a customer. He's allowed to be there." And then when the harassment got worse and it was more often, and she repeatedly went to her supervisor, which was the absolute correct thing to do. Finally, Costco did speak with this individual. So what did the individual do? He would put on sunglasses, he'd put on a hat, he'd go to different aisles, and he would watch her, and he continued to stalk her in the store. She went to her employer and she said, "Look, this guy makes me really uncomfortable. And I have to walk to the parking lot by myself. Can I at least park? Can you make an accommodation for me and give me a spot right in the front where it's right in front of the door?" Costco refused to do that. And it kept getting worse. He kept still coming to the store. Finally, Costco eventually did say to the shopper, "Listen, leave her alone. We don't want you to go anywhere near her." And what did this individual do? The individual then, as I said, just, tried to be, well, his initial response was, "I have a First Amendment right. I can say what I want. I'm a shopper here." And their response was, rightfully so, "No, and we can revoke your privileges." Well, when he continued with the stalking, they did say to him, "Well, okay, don't shop at this store, but go shop at another store." But by this point, she was so concerned that she started to miss work. She became ill. And it turns out that he did come back again to the same store, even though he was told he can't go back to the same store within a year. And that was it. That put her off on a medical leave. She was very concerned. They told her that he hadn't been at the store for some time while she was trying to get better from her medical leave. It turns out she was with her father at a different store. He was at that store and he again approached her. He again did not leave her alone, made similar comments to her. And that was it. That really put her over the edge. And she went on a medical leave. She was out of work for about a year. At that point, Costco ended up terminating her employment because she had been on a leave of absence for so long. She ended up suing Costco, and the court found that she should get back pay. She should get back pay from the time that she was off on a medical leave until Costco terminated her. She was asking for back pay for the whole time period, but the court did say no to that. They basically said, "Listen, They can't have a reasonable policy. A year is reasonable, but you are owed back pay for the entire period of time that you were on a medical leave, because you were on a medical leave essentially because your employer did not take reasonable steps to keep you safe at work and you were sexually harassed in the workplace. So now what I'd like to do is I'd like to go into some of the laws pertaining to discrimination, sexual harassment, so you can understand what the employer's responsibilities are. And then after I go through some of the laws and you have a basic understanding of what the various employment laws are, I'm also going to go into some of the protections that employees have in the workplace and certain leave rights that they have under the various laws. And a lot of these laws I actually did put in my material. So hopefully you will find those materials helpful. And also I'm going to get a little bit into the Wong case because it's a little bit of a different scenario. But first, let me get into some of these discrimination laws. So we have federal law, state law, and local law. There could be other local laws that I did not put in my materials that exist in the state of Illinois. I just put in big ones that I'm familiar with, such as the city of Chicago. And I think I also referenced Cook County. So under federal law, Title VII, it prohibits discrimination based on someone being a member of a protected class, such as gender. And so sexual harassment falls under the gender context. The problem with federal law is it only applies to places of employment with 15 or more employees. But hey, luckily we're in Illinois. And under the Illinois Human Rights Act, you only need one employee. So basically any employer has to follow the human rights laws. And the state of Illinois even takes it a step further. Each of these various laws also have classifications. What is a protected class? So for instance, race, gender, national origin. Those are across the board. But Illinois has things like marital status. The fact that you can't discriminate against someone based on their marital status. So the employer can't just say to the employee, like Sarah, hey, this sounds like it's a domestic problem between you and your ex, go call your divorce attorney and handle it from that perspective. We're not getting in the middle of your divorce. An employer cannot do that because not only is marital status a protected class under Illinois law, but the law protects discrimination based on gender. And as we've seen from the Costco case that I just explained to you, employers have to keep their employees safe from customers. And interestingly, Costco is a federal decision, and the federal courts are far, far more conservative than the state courts. So for instance, in the Wong case, which was a state of Illinois case, which is why I included in your materials, Wong worked at one of these casinos, and there was like a beer tub, and the members of the patrons of the casino would go behind the beer tub and make comments to her and try to hug her and try to kiss her. And she told her employer, hey, you got to protect me. And their first response was, because she recommended, oh, why don't you just put like, one of those ropes in front of me? Like, no, that looks tacky, just maybe position yourself in such a way that they can't get to you. Well, that didn't work. So eventually they did decide to put up, these like barriers so that folks couldn't go behind there, but then they continued to go behind the barrier. And this happened about 5, 6, 7, 8 times. And she felt so uncomfortable, she didn't want to go back to work. And so she sued her employer, and the employer's defense was, we did something. We put up these barriers. She can't establish that it was what's called a hostile work environment. And the court said, no, she has an opportunity to prove her day in court if it really was a hostile work environment, which I'll explain to you in a minute. Okay, so we have federal law, we have state law, we also have city of Chicago law and Cook County. They also have various human rights ordinances. And I'm sure there are other counties within the state of Illinois that also do. I just might not be familiar with them. So you always have to keep in mind federal, state, local law. Sometimes, or what's often that practitioners will do, that they will file lawsuits alleging violations of all three, because even though all three prohibit discrimination, there are different remedies under some of the various laws. And also something very interesting to keep in mind in terms of the city of Chicago is that if you want to file a discrimination claim against your employer, there's a statutory requirement. You have to file a claim within 300 days of an adverse act, and that would be before the Equal Employment Opportunity Commission or the Illinois Department of Human Rights. But hey, we also have the city of Chicago. And under the city of Chicago's law, one has 365 days to file a charge of discrimination before the City of Chicago Commission on Human Relations. So if, let's say, someone is very scared and afraid to come forward and they've suffered an adverse act, well, you have a little bit more time under the City of Chicago's law. And I'll also talk about the Gender Violence Act in a second, because that gives a super long statute of limitations for acts of sexual harassment. Now, what exactly is sexual harassment? In the employment context, it falls into about two categories. One is quid pro quo. Basically, I will do you a favor at work if you do a sexual favor for me. So I have a client right now that actually was working at a major automotive company, and she felt that she was not getting the proper amount of commission. She felt she worked as hard as her similarly situated colleagues, but she was making a lot less, and she wasn't getting the commissions on these big deals. So she went to a manager and she said, "Hey, why am I not getting commissions on these big deals?" And the manager basically said, "No, I can give them to you, but could you do me a favor? Could you send me some nude pictures of yourself?" And she felt awful, but she had a family and she really wanted the money. So she sent the nude photos, and sure enough, she did get the bigger bucks. And it didn't stop there. He then would make comments about how beautiful she was. There's text messaging, and his wife was out of town and he wanted her to come over to his hot tub. And that's when she finally had a complete nervous breakdown. She ended up telling her husband, who stormed there and wanted to beat the guy up, and she became suicidal. She retained me. I actually filed, believe it or not, a workers' compensation case that's currently pending. And I also referred her to a colleague of mine to handle the sexual harassment discrimination case, and she did file in federal court. So now she has two cases that are pending. And the reason why I recommended and I filed the workers' compensation case on her behalf is because she has significant medical bills that the employer should be responsible for paying, which is not necessarily so clear cut under Title VII. There are certain, damages that one is entitled to. It's possible, but then again, there are also other remedies. So when you see these kind of situations, you have to think a little bit outside of the box, and there might be more than one type of proceeding that a person can get benefits from. So that's why there are different laws, and the different laws can help someone in different forms. So that's quid pro quo. I do a favor for you, you do a favor for me in the sexual harassment or sexual favor context. The next is hostile work environment. And hostile work environment isn't necessarily just in the sexual harassment context. It's in a lot of different contexts. So you might hear that name. I know people call me all the time and they say, "Oh, it's a hostile work environment." And it turns out their employers are just not the nicest to them. And as I always say to them, sorry, there's no law against being an equal opportunity asshole, but as long as you're an equal opportunity asshole and don't discriminate, there's really not much I can do. But if the employer does specifically target someone based on their sexuality, then that would be a hostile work environment, such as in the Costco situation, such as in the Wong situation that I just talked to you about a moment ago. And you do have both of these cases. They should be part of your materials. So a hostile work environment has to be severe and pervasive so that it creates an intimidating and offensive and abusive work environment. But courts have said even one comment can be severe and pervasive enough to create a hostile work environment. Those cases are very hard to establish. More often than not, the hostile work environment are continuous type of comments or continuous type of conduct. But there is employer liability, even as we saw in the situation of, let's say, Costco and Wong, where third parties such as customers or vendors or whatnot are involved. Again, very, very important to put the employer on notice. So now that we have an understanding of some of the basic laws that apply, let me add one more law to this mix. This law is really, really important. The Gender Violence Act. The reason why the Gender Violence Act is so important is because it has a very long statute of limitations. Taken out of the employment context, it has a 7-year statute. So for instance, if let's say someone is in an abusive relationship, they can file suit personally against their abuser, and they have 7 years to do so. Because as we know, a lot of victims who are victimized don't feel comfortable coming forward right away, especially a lot of rape victims. It could take years to come forward. And so the Gender Violence Act has been on the books for many, many years to give individuals an opportunity to have state claims, private causes of action, what we will call them, against their abusers. And so normal torts claims like assault, battery, those are 2-year statutes of limitations. So that's why the Gender Violence Act is so important. What's interesting in the employment context is that recently, in the employment context, there was an amendment that's going into effect that gives someone 4 years to file a claim against their employer. So again, we come back to notice. If someone puts their employer on notice that they are being harassed based on their gender, the employer can be held liable. And the reason why this is so important is because they have 4 years to do so, which is very different than the 300-day period that I just mentioned before to file a charge of discrimination before the Equal Employment Opportunity Commission, the Illinois Department of Human Rights, or even the City of Chicago, the 365 days before the City of Chicago. And this is really crucial because if you miss those days, you're out of the box. So for most discrimination claims like race, national origin, etc., your remedy really is generally Title VII, Illinois Human Rights Act, etc. But for sexual harassment, we have the Gender Violence Act, which gives victims time to file a claim against their employer if they blew the statutes on the other claims. And they can go straight to court. They don't have to fiddle around with these government agencies filing charges of discrimination before government agencies. They can file a lawsuit against the employer and against the harasser in a civil cause of action. What's also interesting about the Gender Violence Act is that, like, these other laws, yes, you do have to put your employer on notice, but could also happen in non-employment situations. And let me give you an example. Let's say someone lives in a high rise and they're being harassed by the maintenance person. The maintenance staff makes, sexually charged comments. The maintenance staff perhaps, or a maintenance person touches someone that was inappropriate or unwanted. An individual can put the employer on notice, such as the management company and whatnot, complain about this maintenance person, say, hey, rein in your maintenance guy. And assuming the employer is on notice, the individual can file a lawsuit against not only the maintenance person, but also the employer, even though they're not an employee. So this amendment to the Gender Violence Act really expands it and makes it very clear that you can hold an employer liable, whether it's in an employment context or you're a third party, if they do not take reasonable precautions and reasonable steps to ameliorate the harassing situation, which could lead ultimately to termination if it is warranted. So what happens though where it's not a matter of you're being harassed in the workplace, but you are the victim of sexual harassment or gender violence, or it's, a domestic matters situation? What kind of protections do you have in terms of leave? So for instance, let's say you are in an abusive and harassing situation at home. Can you take time off of work? Is there something like job protected leave? And the answer is yes. We do have a lot of victim protection laws in the state of Illinois. One of them being the Victims Economic Security and Safety Act, which we call VESSA, and I'll refer to it as VESSA. VESSA gives unpaid leave to employees or their family or household members who are the victims of domestic violence, sexual violence, gender violence, or any other crime of violence. And this even applies to small employers. So a lot of folks think about FMLA, the Family Medical Leave Act. Well, the Family Medical Leave Act does not cover a lot of employers because in order to have FMLA, the employer has to have at least 50 employees that work in a 75-mile radius from one another. So smaller to mid-sized employers with less than 50 employees are not going to be covered by FMLA. So most folks don't know about these other leave laws. They just know about FMLA. So under VESSA, for instance, a person who is employed, let's say by a small business that has only 1 to 14 employees, can get 4 weeks of job protected leave to take care of a harassing situation, to, let's say, go to court, to get that order of protection. Now, they do have to put their employer, on notice. They, do need to provide certain documentation to the employer to certify that they need VESSA, such as a police report, a court order, a letter from a clergy, a letter from an attorney. But they do get this job protected leave under VESSA. For large employers that are covered by FMLA, then VESSA leave would be consistent. They could get 12 weeks of job protected leave. Now, it is unpaid, but job protected leave means that they get their job. They have to be returned to the equivalent job, if not the very same job, with the same benefits. So the employer does not have to continue, let's say, to accrue, vacation time or paid time off if they're on an accrual system while the person is off, but they have to maintain their health insurance benefits. They can require the individual to pay the employee portion, just like when they're actively employed. So for instance, when you get your paycheck from your employer, the employer does deduct from health insurance. So you might be responsible for paying the employee portion so that you can continue those benefits, but it does not trigger COBRA. The employer still has to continue with those benefits, the retirement, the health insurance, and whatever other benefits the employee is entitled to during that period of job protected leave, even though it is unpaid. Certainly the employer can have benefits that are better than the law and pay. Some employers, even some very small employers, are very generous. Like I have a client, very small employer, less than 10 employees in the financial services industry. And this individual in particular is very, very generous. She gives more than FMLA leave, if folks have children or whatnot, and she gives it all paid, not required by law. So certainly you can give these benefits if you are, and certainly it does from the perspective of someone who represents both individuals and employers. The better the workplace is, the more supportive you are of your employees, the better the work product is going to be. So even from a selfish perspective, it's really important for employers to protect their employees in various situations as reasonably possible as possible. So for instance, that's VESSA. Starting January 1st, I should actually say, well, January 1st for the state of Illinois, there is mandatory paid leave. So if you are such a small employer that you don't have paid leave, there's a certain amount of paid leave that you will need to give to your employees. And starting December 31st, 2023, so this year, the end of the year, the city of Chicago is mandating paid sick leave, 5 days, and 5 days of paid time off. And so there might be other benefits, even if you work for a very, very small employer, that you can get a certain amount of leave that is paid under the various laws that we have. Something else that I think is important to point out to folks is that
Helen,
it's very,
we got a question related to that. Just
Okay.
as long as we're on this.
Sure.
It runs along with FMLA from what I was told by the Department of Labor. So if
if an
6
employer,
weeks, you only have 6 weeks left for VESSA.
so
So is
if,
that true? Do they run concurrent or do they run? I can't think of what the other one's called.
okay, so if the employer is large enough to afford FMLA benefits to their employees, okay, such as 12 weeks of job protected leave under FMLA, then yes, VESSA and FMLA may run concurrent if that is what the employer chooses to do. There's no law requiring an employer to provide 12 weeks of job protected leave under FMLA, an additional 12 weeks of job protected leave under VESSA, which would be a total of 6 months of job protected leave. And the reason why I think that is important to note is because VESSA leave is not 100% exactly the same as FMLA. And what I mean by that is leave, yes, but the reasons for VESSA leave might not qualify under FMLA. So while the two can run concurrent, if that's what the employer requires, that's certainly supported by the law. VESSA, though, does give certain protections to individuals to take leave when that leave would not be something afforded to that individual under FMLA. And here's what I mean specifically by that. Under VESSA, let's say the person needs a certain amount of time off for court, to go to court. That would not be for a serious health condition under the Family Medical Leave Act, because FMLA is designed to give leave for medical. That could be mental health. That would be a serious medical condition affording for FMLA. But, you know, aside from the need for leave, let's say for mental health or whatnot, that's why VESSA, Illinois instituted VESSA, because VESSA is really targeted to victims and their safety. And it might not be the same as an FMLA leave. Anything else, or should I go on?
No, that's good. Thanks. There was another question about male versus female, but we can get to that at the end.
Okay. So one thing I tell folks, especially for those domestic relations attorneys out there who are advocating for their clients, tell your clients to read their employment handbook. Oftentimes, especially small employers, don't even know what's in there. And even large employers, because oftentimes folks know, yeah, I need a handbook, and they'll contact their payroll service company, their ADP or whatnot, and they'll provide a handbook. They won't read it. I've had so many businesses that I've drafted their handbooks, and what I do is before I'll draft handbooks for an employer, I'll ask them what they have currently, and I'll go through it because I want to know, is this something that they specifically want in their handbook? Because the handbook should be targeted to the culture of the employer. And oftentimes the employer's like, I have that in my handbook? I didn't know I had that in my handbook. So like, for instance, you'll see sometimes an employer with less than 50 employees have FMLA. They'll say, hey, did you intend for there to be FMLA? And they're like, what do you mean I don't have to do this? I'm like, no, you don't have 50 employees. Why are you giving a benefit that you don't need to give and that extra cost? But sometimes stuff like that is in there. So read your handbook, because if your employer has in their handbook that they'll provide FMLA leave, even though they don't have 50 employees, well, if it's in their handbook, that's a benefit that they're providing, and you should ask for such leave. Maybe there are other benefits that are in that handbook. More important, or equally important to knowing what the benefits are, is to knowing how to ask for them and how to approach the employer, because you want to follow the requirements in the handbook so that you get the benefits afforded to you. So you want to know what your employer's policies and procedures are so that you can rightly ask for the benefits to which you're entitled. And if you don't see those benefits, then you do need to know the law, and you need to go to your employer and say, look, this is a problem, report it, because ignorance of the law in this situation is no excuse. So if you do put your employer on notice that there is a problem, there's a harassing situation, or you need time off from work because of a private domestic matter, you have to educate your employer and say, look, I'm coming to you, unfortunately I have this situation, I'm going through a divorce, it's challenging, it's difficult, I need to go to court, I need some time off. And the employer says, well, hey, it's this is like a busy season, it's like end of year, holiday sales. And say, look, I'm really sorry, but I really need this time off. But you do need to follow the requirements for the notice and whatnot, and provide that to your employer. So it's really, really important to know what your benefits are, to know what it says in your handbook. Employers are also, under Illinois law, required to give training, mandatory training to their employees under the state of Illinois. Once a year, they're required to give an hour training. Under the city of Chicago, not only do they have to give sexual harassment training to employees, but there's an extra hour for bystander training. Now, what is bystander training? What's the requirement of bystanders? Well, employers are responsible to teach their employees, at least in the city of Chicago, what happens if a coworker observes harassment. So let's go back to our original scenario of Sarah. If a coworker saw the ex stalking Sarah at work, the coworker should have some sort of training to say, hey, Sarah, I saw this. Is this a problem? Can I help you? You know, let's go together to our supervisor. Let's tell our supervisor the situation at work. The Costco situation, that's what the court dinged Costco on also, is that, you know, there wasn't proper training. The supervisors were told, other coworkers were told, and they didn't take the proper steps. So even if you're not, let's say, in the city of Chicago, I would say do that bystander training as part of your annual sexual harassment training. Let folks know what to do in the workplace if you observe harassing situations. How do you make complaints? Who do you make complaints to? Who do you report it to? If your supervisor is the harasser, who's an alternative person that you could go to explain that you are in a harassing or challenging or, you know, difficult situation at work. So it's really important to know your rights. It's important to know your employer's policies and procedures, so that you know what your rights are and can advocate for yourself. I think I've talked enough. So do folks have questions? I see we have like about, 15 or so minutes left. I'm certainly happy to keep talking, but I'm certainly happy to open the floor for questions or comments, or to discuss more scenarios if you want.
Okay, so we had one question and it's in there, and I think if I get this, hopefully I get this
Here.
right.
I'll look in the chat. I haven't looked.
Yeah, if the employee of any gender is the one harassing the employer of any gender. So in that situation, do you simply fire them, or is there more to this? I think the question is, does it have to be the opposite gender in order for
Great
us
question.
Yeah,
Great question. There is a case involving Rosebud, okay? And it was male on male sexual harassment. And the court, this was the Seventh Circuit, again, the more conservative federal court, that ended up doing a backbend basically to distinguish this case from a precedent of other cases to establish that you can have same gendered male on male sexual harassment. And what I mean by backbends is that, and I'll tell you a little bit about the facts in the Rosebud case. There was these guys working in like the meat cutting area. I mean, it's been a while since I read this case, so I think these are the facts. There are these men in the meat cutting area, and there was one meat cutter in particular in like this food area where they would pinch him in the butt. They would like make comments about him, sexually charged comments about him, and he told them to stop it, and he kept complaining, and Rosebud wouldn't do anything about it. And so he finally filed a charge he said, I'm going to file a charge of discrimination. And he did. And then his tires were slashed. And he was so freaked out that he ended up quitting. He was scared for his life, because at that point, when he filed the charge of discrimination, yes, the employer finally said to the guys, cut it out, stop grabbing him and poking him and doing these things. Like, another thing they would do is they would like put like, when they would pass an item one time, they had like knives on the end of the board when they passed the item to this employee. And again, this was all males. And after he said cut it out, he filed his charge of discrimination. His tires were slashed, and he quit. And he sued for constructive discharge. Constructive discharge basically means the place of employment is so intolerable, that no reasonable person could work in this place. And it's as though the employer terminated me. That's what constructive discharge is. And so when he filed his lawsuit, actually the lower court dismissed it. They basically said, oh, this is horseplay. There's all these cases that talk about horseplay at work. This is not sexual harassment. And the Seventh Circuit said, no, 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 no. They went through these various cases and they distinguished the horseplay from what is male on male sexual harassment. There's also something that, for instance, the Equal Employment Opportunity Commission has termed the Queen Bee Syndrome, that sometimes females have a hard time working for other females, and that other females can act with an air of superiority and discriminate based on gender to other females. I had a situation one time where I negotiated a severance agreement. It wasn't sexual harassment, but it was gender discrimination, where my client was a highly valued employee. There was a coworker that was just miserable to work. My client happened to be African American. This other employee happened to be Asian. It wasn't based on either's national origin at all, or the fact that my client was an African American. It was really based on the fact that my client was female. This other individual wouldn't invite my client to certain meetings, said outright, I work better with men than with women. And it just became an intolerable situation where my client complained. The employer did an investigation, and this is where the employer went wrong, because I honestly think if the employer said something slightly different, my client would not, I would not have negotiated an exit packet. Let's just put it that way. I think my client would still be working at this Fortune 500 company. But the employer did find that this other individual made comments that were inappropriate, that were wrong. They moved this person's office, so it was no longer next to my client's office. They mandated that the employee went for training. So they did all the right steps in terms of the end. What was the problem? They would not admit it was gender-based discrimination. They just said, it wasn't so appropriate. So we're sending this individual for some training. We're going to move the office. My client was so incensed, and honestly, they would not have been exposed to liability because they did all the right things. They would have had what's called a fair alert defense, which is once they were on notice, they took corrective action, they did the proper thing, but they just couldn't say it was discrimination. And had they just been able to say it was discrimination, my client would have been happy to continue to work there. So this is a message for all you folks who are business owners. There's a way to do it where you're not exposing yourself to liability, but you keep your staff happy. You help them feel vindicated for bringing the problem to your attention. So there are two examples of, I would say, same-sex gender discrimination.
We'll try, and I just tried to look, and unfortunately, Rosebud's had many cases against them. So we'll try and get those cases over to people when I send out the CLE certificates for those who want it, and maybe I'll send it to everyone. I think
I can easily. The Rosebud case I have as my research file. So if folks want the Rosebud case, I'm happy to.
That'd be great. We will share that with everyone. That'd be great. Which we'll share that with everyone. And then another question: can you name the different types of leave protections? Again, you gave the different statutes for different avenues, but can you just list some of the most commonly used leave protections to look into? I believe that's in our materials in the outline, but do you want to go through that again real quick?
I did put VESSA leave in the outline. I did not put FMLA in the outline. The only reason why I did not put FMLA in my materials is because it's not sexual harassment, domestic violence specific. But sure, family medical leave is leaves. Under state law, the state of Illinois, there is paid leave where someone starting January 1st is entitled to earn an hour for every 40 hours worked, capped at 40 hours, to be able to use that leave for any reason. And if the reason is foreseeable, then you can be required to give your employer 7 days notice. But if the reason is unforeseeable, then you would have to give notice as soon as practicable. Under the City of Chicago's paid leave and paid sick leave ordinance, which is going into effect starting December 31st, 2023, you earn 1 hour of paid leave and 1 hour of sick leave for every 35 hours worked, capped at 40 hours for each. So up to 5 days of paid leave, 5 days of sick leave. What's very interesting that you should know about the City of Chicago is that unless the ordinance it's challenged at some point, which I wouldn't be surprised because it is so broad. If you work for 2 hours in any 2-week period in the City of Chicago, that ordinance applies. So for example, let's say you have an employer in Skokie and you live in Skokie, but you are sent on sales calls in Chicago. You're not merely just driving through Chicago to get to Indiana, but you literally actually physically are present in the City of Chicago to do work. That City of Chicago ordinance will apply. And so if your employer does something which a lot of employers do, which is accrue time over a certain period of time, then under that city law, you are entitled to carry over some of that leave. Specifically, I'm thinking the sick leave is going to carry over, because a lot of, employers don't necessarily distinguish between paid leave, sick leave. So it might be important for you to bone up on your city of Chicago, even though you think city of Chicago is not going to apply, because unless or until it gets challenged, that is going to be the law going into effect in the city of Chicago come the end of this year. And I think the ramifications for that law are going to be broad. So generally speaking, the leaves are going to be FMLA, VESSA. There is, let's say, a bereavement leave if there are a certain amount of employees. There's also school visitation leave. So there are a lot of different kinds of leave that do apply in the state of Illinois, city of Chicago, depending on the number of employees, depending on where the employer is located, again, whether the city applies or the state applies. There's also time off for voting. So there are a lot of different nuanced leaves that may apply in varying situations if you are employed in Illinois. Other questions?
We've got a few questions on just the kind of paperwork and administrative. We only offer CLE, so continuing legal education. We're not authorized to do CEUs, for those of you who are asking, unfortunately. So I'm not seeing any other questions. There was a question originally about in your initial scenario is whether or not there were DV allegations in the divorce. Would that have made a difference in that initial fact pattern that you had? I don't think it would have.
Vicki, I don't understand the question exactly. Can you repeat it?
I think that in the Sarah situation that you gave at the beginning, where it was her husband, right, that was coming in to the workplace and harassing. Does it matter whether or not there are domestic violence allegations in the divorce for her to be protected?
No,
I didn't think so. Okay.
What is the allegations are required is really, it doesn't have to, they don't have to be married. Look, the Costco situation, the Wong situation, it had nothing to do with domestic relations, which are actual, real cases. Rosebud had nothing to do with, domestic relations. So an employer would just have to look at this scenario and take out of the scenario the fact that these two people were married, and just look at it like any other analysis in the workplace. Is a customer, third party, harassing my employee in the employment context? And there's something else also I should bring to your attention too that gets sticky. This isn't necessarily domestic violence, but really more a matter of discrimination based on marriage. Every once in a while, it's a nightmare for someone who actually has a business that represents businesses, but every once in a while you have married couples working at the same place of employment, and that's when it becomes really challenging, because if they do get divorced, you can't discriminate against the individuals. I had a potential client who contacted me one time, who she and her husband had started a business that was bought out by another business. And this buyout was, let's say, 10 years ago. So they've been working for this other company for 10 years. And the two of them got divorced. And she felt that she was going to be terminated by her employer because the ex-husband made more money for the business, was in a higher position of power, and was really concerned about this. And those situations are really sticky and very challenging, but the employer really does have to be very careful. One of the rules that I give to my business clients is you have to treat employees equally. You can't show favoritism, because once you start showing favoritism, practically everyone is part of a protected class, as you can tell. And so then you will open yourself up to liability. The only times where I tell employers that you can treat people differently is in the context of disability and religion. And those you analyze on a case-by-case basis in terms of accommodations. And even in that context, if you give certain people accommodations for religion or for disability under the Americans with Disabilities Act, if someone else, a different employee, has a similar situation in the future, you better treat them the same as you treated those other individuals with respect to their accommodations. So, you know, it's really challenging when you have, let's say, people who are in who are romantically involved, both working at a place of employment. That's why some employers do have nepotism policies in which they don't, you know, hire, you know, children, brothers, sisters, husbands, wives, because it can get very messy. And in the context of the individual who contacted me to represent this individual, I mean, absolutely, her employer should not discriminate and cannot terminate this individual, and the former spouse should not have undue influence over the employer, even if it's a matter of this individual, you know, makes more money and that person's position is more significant. You have to be very careful and document, which is what I tell my business clients, you know, make sure if certain situations happen, you put a note in the personnel, and it's part of the personnel records that you had a conversation, that someone complained, what happened. Keep your investigative notes separate from your, you know, personnel records. You know, do an investigation when someone brings a good faith-based complaint. Doesn't necessarily mean that the person is right or they're wrong, but if someone brings a good faith-based complaint, you are on notice. You must investigate. And I would keep those investigative notes.
Great, thank you. Thank you. I'm looking, there's some more questions about.
And I'm happy to stay, you know, a
Yeah.
little longer if I know
Yeah,
people
I'm
probably
gonna
gonna
go
start,
ahead. I know
I'm happy
we're
to.
getting, yeah, we're getting close to the 1 o'clock wishing hour. So I'm gonna go ahead and put the survey link.
And I can even, while you put the survey up, I can even look for that Rosebud case and see if I can put it
So
in
if people can
the
take that
chat.
survey, it's very much appreciated. It looks like someone has their hand raised. And then there was another question about what if the employee is female and is the one harassing the employer male?
The analysis is still the same.
Yeah.
You know, you have to, and that happens. That definitely happens all the
Right.
time. There are women who, for lack of a better term, grab guys' balls in the place of employment, and that is wrong, and that is sexual harassment, and that cannot be tolerated. You cannot treat women differently than men. You have to treat those complaints the same and investigate.
Okay. And then Shelley Sandow has her hand raised. So I'm going to allow you to talk, Shelley. Shelley, are you still there?
Hi, Shelley. What's up?
You need to unmute yourself now. There
I'm
you go.
sorry, I pressed that button in error.
Okay, we can hear
I'm
you.
sorry. I made a mistake. I pressed the wrong icon. I don't have a question.
Okay.
Well, nice meeting you, Shelley.
Oh, that's funny. All right. Anyone else? Well, lower your hand, Shelley. Didn't mean to put you on the spot. Okay, I'm just going to check the Q&A one more time. This has been great. Thank you so much, Helen.
Sure.
I think we've got everything. We will. Did you find the name of that Rosebud case or?
I am still looking. Oh, Smith v. Rosebud. Okay, so let me see if I can copy this into the
We at least
chat.
put the case name in there, Smith v. Rosebud, and it's a Seventh Circuit case, you said?
It's 7th Circuit. And, see if I can.
Federal court.
Okay, I just posted it.
Perfect.
in there.
Fantastic. So there you guys have it. I'm actually gonna download it myself so that I have
I'm
it.
pretty sure. Yeah. Sorry, you can ignore my little notation. That's like how I kind of distinguish the case on my computer from some of the others. So
Okay, I've got it. No, I like that distinguishing. All right. If there's nothing else, please make sure you take that poll. Thank you again to Helen. If you are so moved and want to support the work that we do, I have put in there, you can text HOPE to 345-345 to make a donation or click on our link. We really appreciate any and all help on that so we can continue to do these kinds of programs as well as helping our clients with counseling and other supportive services. The one other thing that I wanted to mention is that we are always looking for attorneys to represent our clients on family law matters. If that is something that you are interested in, I am going to also put a link in for you to just be able to quickly share your information with us, and we will get in contact with you. Not all of our cases are pro bono cases. We certainly have some, but some of our cases are actually fee generating cases. So we're looking for attorneys who have a trauma-informed kind of practice so that they can, I probably should put myself back on. Sorry, as I'm saying all this. We are always looking for attorneys that have a trauma-informed practice and are willing to work with our clients on their family law matters or on other matters as well. Sometimes there's a real estate matter or something else that comes up, and we're looking for attorneys who can help out our clients who are all survivors of domestic abuse. So, oh, I see a couple more. Wait, let me just make sure there's no other questions. Okay, someone said that the survey isn't submitted.